डॉक्टर बाबासाहेब आंबेडकर ओपन यूनिवर्सिटी.
Namaskar. I'm Dr. Dhaval Pandya. Welcomes you all from the Chaitanya Studio of Dr. Babasaheb Ambedkar Open University. Today we are going to learn about MBA's Semester 1, subject Business Law. This unit is continuation with previous unit. First we'll see the syllabus and then we'll continue. MBA Sem 1, Semester 1's subject Business Law. Code of the this subject is MBA01C106, Unit number 2, Indian Contract Act 1872, Part 2. It covers many things, as we can see, starting from discharge of contract, remedies to breach of contracts, performance of contracts, void agreement, contingent contracts, quasi-contracts, special contracts, contracts, indemnity and guarantee, contracts, bailment and pledge, and contracts of agency. In previous lecture, we learned about performance of contract, void agreement, contingent contract and quasi-contract. In today's lecture, we are going to learn about special contract, in which contracts, indemnity and guarantee will learn, and contracts, bailment will cover these two things. So, special contract, indemnity and guarantee, and contracts of indemnity. These two things we are going to learn. Okay. Indemnity and guarantee and contracts of indemnity. A contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself, or by the conduct of any other person, is called a contract of indemnity. Section 124. The person who promises to make good the loss is called the indemnifier, promiser, and the person whose loss is to be made good is called the indemnified or indemnity holder, promisee. A contract of indemnity is really a class of contingent contract. A contract of the fire insurance or marine insurance is always a contract of indemnity, but there is no contract of indemnity in case of a contract of life insurance. There may not be a void contract of indemnity where it is against public policy. The most common use of the term indemnify and indemnity occurs in insurance policies. When purchasing an insurance policy, the insurance company agrees to indemnify the policyholder or another specified party against losses or damages that may occur. According to the definition given by section 124 of the Contract Act, contract of indemnity includes: 1. Only express promises to indemnify, and 2. Causes where loss is caused by the conduct of the promiser himself or by the conduct of any other person. It does not include A. Implied promises to indemnify, and B. Causes where the loss is caused by accident or by the conduct of the promisee. Now, commencement of indemnifier's liability. Commencement of indemnifier's liability. High Court have differed in their judgment regarding commencement of indemnifier's liability. According to High Court of Calcutta, Madras and Allahabad and Patna, indemnity holder when asked to meet a liability can compel the indemnifiers to put him, indemnity holder, in a position to meet the liability without waiting until the indemnity holder has actually discharged it. Right of indemnity holder. As per the section 125, the rights of the indemnifier holders are: first, damages. In a contract of indemnity, the indemnity holder is entitled to recover from the promises and the indemnifier all the damages for which he may be compelled to pay in any suit as of any matter to which the promises of indemnity applies while acting within the scope of his authority. Second, costs. Any person with indemnity holder and indemnifier or promise is entitled to recover from promisor all costs which he may be compelled to pay in any suit is bringing or defending it if he does not go against the order of the promisor, and if he has act in absence of any contracts as would have been prudent for him to do. Third, sums. An indemnity holder is entitled to recover from indemnified all sums which he was paid under the terms of compromise of any suits, and compromise was not against the order of the promisor, and the compromiser was not against the order of the promisor, and the compromisee was such that it was to be done prudent in absence of any contract of indemnity. So, after clarity of this thing, contract of guarantee. We will learn about contract of guarantee. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written, section 126. It may be express or implied and may even be inferred from the course of conduct of the parties concerned. Essential of a contract guarantee, contract of guarantee, essential. First, concurrence of all the parties. All the three parties, namely the principal debtor, the creditor and the surety, must agree to make such a contract first. Second, liability. In a contract of guarantee, liability of the surety is secondary, like the creditor must first proceed against the debtor, and if the latter does not perform his promise, then only he can proceed against the surety. Third, existence of a debt. A contract of guarantee presupposes the existence of a liability which is enforceable at law. If not such liability exists, there can be no contract of guarantee. Thus, where the debt which is sought to be guaranteed is already time barred or void, the surety is not liable. Fourth, consideration. There must be consideration between the creditor and the surety so as to make the contract enforceable. The consideration must always be lawful. In a contract of guarantee, the consideration received by the principal debtor is taken to be the sufficient consideration for this surety. Thus, any benefits received by the debtor is adequate consideration to bind the surety, but past consideration is not consideration for a contract of a guarantee. There must be fresh consideration moving from the creditor. Fifth, writing not necessary. A contract of guarantee must either be oral or written. It may be expressed or implied from the conduct of the parties. Here we should note that a contract of guarantee is always in writing under English law. Sixth, essential of a valid contract. It must have all the essential of a valid contract such as offer and acceptance, intention to create a legal relationship, capacity to contract, genuine free consent, lawful object, lawful consideration, certainty and possibility of performance and legal formalities. Seventh, no cancellation of facts. The creditor should disclose of the surety of fact that are likely to affect the surety's liability. The guarantee obtained by the cancelment of such facts is invalid. Thus, the guarantee is invalid if the creditor obtain it by the cancelment of material fact. Number 8, no misrepresentation. The guarantee should not be obtained by misrepresenting the fact to the surety. Though the contract of guarantee is not a contract of agreement filled like of absolute good faith and thus does not require complete disclosure of all the material fact by the principal debtor or creditor to the surety before he enters into the contract. But the fact that are likely to affect the extent of surety's responsibility must be truly represented. And ninth, final, in case co-sureties does not join, see section 144, where a person gives a guarantee upon a contract that that the creditor shall not act upon until another person has joined in it as co-surety, the guarantee will be invalid if the other person does not join. Now, after essentials of contract of guarantee, we will see about kinds of guarantee. Kinds of guarantee. Contract of guarantee may be of two types, one specific or second continuing. Specific guarantee. First, specific guarantee. Specific guarantee means a guarantee given for one specific transaction. In this case, the liability of the surety extends only to a single transaction. Second, continuing guarantee. Section 129. A continuing guarantee is that which extend to a series of transactions. Section 129. It is not confined to a single transaction. Surety can fix up a limit on this liability as to time or amount of guarantee. When the guarantee is a continuing one, the fact that the guarantee is continuing can also be ascertained from the intention of the parties and the surroundings circumstances. Now, third, rights of a surety. Rights against the creditor. First, Section 133, the creditor ought not to change terms of the agreement between the creditor and the principal debtor without the surety's assent. Any such change release the surety as to transactions ensuring to the difference. However, in the event that the change is for the profit of the surety does not prefer him is as an irrelevant character. It might not have the impact of releasing the surety. Second, Section 134. The creditor ought not charge the principal debtor from his liability under the agreement. The impact of the release of the principal debtor is to release the surety too. Any enhancement or execution from the creditor which is law has the impact of releasing the principal's debtor puts the clause to the liability of the surety. Third, Section 135. In the event that an agreement is made between the creditor and principal debtor for intensifying the last liability or making a guarantee to him growth of time for doing the comments or swearing up the down to not to beyond any debt, release the surety unless the consent to such an agreement. Section 139, fourth, Section 139. The surety is released if the creditor debtor's weakness, the surety is possible remedy against the principal debtor. After this, we will see the contract of bailment. Contract of bailment. The term bailment is derived from French word bailer. Bailment derives from the French word bailer, which means to deliver. Bailment is a delivery of goods on condition that the reception shall ultimately restore them to the bailer or dispose of them according to the direction of the bailee, or dispose of them according to the direction of the bailer. Requisites of bailment. Contract First contract, a bailment is usually created by agreement between the bailer and the bailee. The agreement may be express or implied. In certain exceptional cases. Bailment is implied by law as between a finder of goods and the owner. Second, delivery of possession. A bailment necessarily involves delivery of possession of goods by bailer to bailee. The basic feature of possession are control and an extension of exclude others. Extension to exclude others. As such, mere custody of goods does not create relationship of bailer and bailee. A servant who receives certain good from his master to take to a third party has mere custody of the goods. Possession remains with the master and the servant does not become a bailee. Thus, to create bailment, there must be delivery of goods. Second, movable goods. It should be noted that in bailment only the possession of the good is transferred, not the ownership. Against only movable goods can be bailed as movable goods cannot be delivered. It is the main feature of bailment that it is only for the movable property and not for the immovable property. Fourth, for some purpose. The delivery of goods from bailer to bailee must be for some purpose. If goods are delivered by mistake or a person, there is no bailment. Fifth, return of specific goods. It is agreed between the bailer and the bailee that as soon as the purpose is achieved, the goods shall be returned to dispose of according to the direction of the bailer. For a transaction of bailment, it is necessary that the same good must be returned. If the goods are not to be specifically returned, there is no bailment. But there is a bailment even if the goods bailed are in the meantime altered in form, like when a piece of cloth is stitched into a suit where money is deposited in a savings bank's account or any other account. It is not a transaction of bailment because the bank is not going to return the same currency notes but will return only an equivalent amount. However, where money or valuables are kept in safe custody, it will amount to a transaction of a bailment as there will be refund in the spice. Sixth, consideration is not necessary in case of contract of bailment. In case of bailment, for mutual benefit of the bailer and bailee, consideration is there for both the parties, like given his watch for repair to A gives watch for repair to B for rupees 10. For A, consideration is repair for which and for B, consideration is rupees 10. However, in case of bailment, either for the benefit of the bailer or bailee alone, consideration in the form of something in return is not there. In such cases, the deterrent suffered by the bailer in parting with the possession of goods is considered as a sufficient consideration to support the promises on the part of the bailee to return the goods. Now, duties of bailer. Duties of bailer: to disclose known faults. It is the first and foremost duty of the bailer to disclose the known faults about the goods bailed to the bailee. If he does not make such disclosure, he is responsible for any damage caused to the bailee directly from such faults. Section 150, para number 1. Second, the bare extraordinary expense of bailment. The bailee is bound to bear ordinary and reasonable expenses for the bailment, but for the extraordinary expenses the bailer is responsible. Third, to indemnify bailer for loss in case of premature retirement of gratification bailment. A gratification bailment can be terminated by the bailer at any time, even though the bailment was for a specified time or purpose. But in such a case, the loss occurs to be bailee from such premature intention should not exceed the benefit he has derived out of the bailment. If the loss exceeds the benefit, the bailer shall have the indemnify the bailee. Section 159. Fourth, to receive back the goods. It is the duty of the bailer to receive back the goods when the bailee returns from after the expiry of the term of the bailment, or when the purpose for which bailment was created has been accomplished. If the bailer refuses to receive back the goods, the bailee is entitled to receive compensation from the bailer for the necessary expenses of custody. Fifth, to indemnify the bailee. Where the title of the bailer to the goods is defective and the bailee suffers as a consequences, the bailer is responsible to the bailee for any loss which the bailee may sustain by reason that the bailer was not entitled to make bailment or to receive back the goods or to give directions respecting them. Section 164. Now, duties of bailee. To take reasonable care of the goods bailed. First, not to make any unauthorized use of goods. Second, third, not to mix the goods bailed with his own goods. And fourth, not to set up an adverse title. Section 117 of the Indian Evidence Act 1872. Fifth, to return any accretion to the goods, and sixth, to return the goods. Now, rights of bailer. Enforcement of rights. First, avoidance of contract. Second, return of goods, length, gratuation. compensation from a wrongdoer. Now, the rights of bailee, delivery of goods to one of the several joint bailers of goods. First, delivery of goods of bailer without title. Third, right to apply to court to stop delivery. Fourth, a right of action against transparencies. Fifth, bailee lien. First, particular lien, general lien, then termination of bailment. Okay. Now, termination of bailment. Okay. A contract of bailment is terminated if the in such cases. First, one of the expiry of the period. When the bailment is for a specific period, it terminates on the expiry of that period. First. Second, on the achievement of the object. When the bailment is for a specific purpose, it terminates as soon as the purpose is achieved. Third, inconsistent use of goods. When the bailee uses the goods in a manner inconsistent with the terms of the contract, the bailment terminates. Section 154. Fourth, disruption of the subject matter. A bailment is terminated when the subject matter of the bailment A is destroyed, or B, by reason of the change in its nature, becomes incapable of use of the purpose of the bailment. Fifth, gratuation in justified bailment. It can be terminated any time subject to condition laid down in section 159. And finally, sixth, death of the bailer or bailee. Gratuation bailment is terminated by the death either of the bailer or of the bailee 162. With this note, we complete our today's lecture. Now, long and short questions and short notes. First question can be, what is indemnity and guarantee? Discuss in detail. What is contract of indemnity? Discuss in detail. Essentials of contract of guarantee, and last, rights of bailment. Okay. So, with this note, we complete today's lecture. We'll meet in continuation in the same unit. Till then, thank you.